Hello and thank you for joining us again for another episode of Kidnapped Hearts, the weekly TV show brought to you by the International Criminal Court against Child Kidnapping. We are committed to bringing you the ugly truth about the corrupted family court systems and heinous crimes against children, which the government continues to turn a blind eye to. In our last episode, Dark Secrets, Parental, Child Abduction and Non-Hague countries, we talked about the ins and outs of what really goes on when children are kidnapped and taken to countries which have not signed up to the Hague Convention. If you haven't already seen that episode, then we strongly recommend that you do. That episode will be particularly useful for anyone who had a child with someone from a different country, especially if that country is not signed to the Hague Convention. This week, we'll be talking about what happens when children are abducted to countries which have signed to the Hague Convention, yet the left behind parent still experiences challenges with having their child returned. Yes, that's right. It's sad to say, but unfortunately, signed up to the Hague sometimes can mean very little for the left behind parent, who is simply caught in limbo in a lackadaisical system that is failing to protect the very children it promised to look after. It's a scary and daunting prospect, and we work with parents all the time who face the horrible challenge of having to recover their missing child. So if anyone is facing this current predicament or knows anyone who is, then it really is important that you stay tuned for this episode. But before we go any further, as a disclaimer, we must stress that this episode is not about breaking the law or doing anything illegal. And even though not all officials are crooked, that doesn't mean that you should let your guard down. Furthermore, whatever we say here should also not be viewed as legal advice. If in doubt, it's always recommended to speak to your lawyer. And if you do need legal help, you're welcome to contact our office, where we can give you further advice. In our previous episode, we already discussed the Hague Convention at length. It's basically a multilateral treaty that demands a swift and safe return of any child who's been abducted by a parent. But just to briefly recap for the benefit of anyone who is still not up to speed, the convention requires a return of a child who is a habitual resident in a contracting party immediately before an action that constitutes a breach of custody or access rights. The convention provides that all contracting states, as well as any judicial and administrative bodies of those contracting states, shall act expeditiously in all proceedings seeking the return of a child, and that those institutions shall use the most expeditious procedures available to the end that final decision to be made within 6 weeks from the date of commencement of the proceedings. The convention provides that the removal or retention of a child is wrongful whenever a. It is in breach of rights of custody attributed to a person, an institution, or any other body, either jointly or alone, under the law of the state in which the child was habitually resident immediately before the removal or retention, and b. At the time of removal or retention, those rights were actually exercised either jointly or alone, or would have been so exercised but for the removal or retention. These rights of custody may arise by operation of law, or by reason of a judicial or administrative decision, or by reason of an agreement having legal effect under the law of the country of habitual residence. I know what you're thinking. It sounds like it should be a clean-cut case for anyone who had their child wrongfully taken to one of these countries that have signed onto the Hague, right? You'd imagine if your ex-partner abducted your child that you can just make a couple of calls and expect the child to be returned pretty quickly, right? Well, you could not be more wrong. Sure, in theory we wish that it did work like that, but unfortunately it can sometimes be anything but straightforward or easy. One of the problems is that there are a few loopholes in the Hague Convention just waiting to be exploited, that many cunning and deceitful parents have started to work around. Stephen Said's daughter, Nolene, was abducted by her mother in August 2013 and taken to France. As France is one of the signatories to The Hague, Stephen suddenly found himself in a situation of very rude awakening when he endeavoured to have his daughter return to New York City, where she was born. He told his story in the Huffington Post. The last time I saw Nolene before she was kidnapped was Monday, July 29th, 2013. She'd spent 4 joyous weeks with family and me on summer vacation. She then flew to France for a 4-week vacation with her mother, who was ordered to return to the United States with her no later than August 27, 2013. Nolene was enrolled, tuition already paid for the coming year at her school of 3 years, the Lycée Français de New York. Everyone thought she was coming back. But on Friday, August 29th, as my wife and I prepared Nolene's bedroom with gifts for her return celebration, half an hour before I expected to pick her up, I received an email from a French lawyer informing me Nolene was not back in the US, that she was supposedly being held in France by French authorities, and that she would never be returning. Despite our ironclad custody agreement preempting any legal proceedings in France whatsoever, the mother and her French lawyer filed her disproven claims of abuse in a remote town in France. She demanded full custody and the protection of the French courts, claiming that the US and New York justice system and child protective services had failed to protect Nolene from years of supposed abuse that never occurred. The therapist whom the mother had manipulated without obtaining any written release nor ascertaining the facts of our case, aided the mother, supplying her with letters and a false report claiming abuse had taken place, in complete contradiction of all of the Supreme Court orders and CPS investigations proving it was a ruse. The mother built her entire case on these false documents. The US Department of State, the FBI and our lawyers advised us not to pursue criminal charges for federal kidnapping. They assured us that given the strength of our case history, my daughter would be returned under application of the Hague Convention on the civil aspect of international child abduction. My lawyers also advised that because we had a return date on October 3rd already scheduled in Queen's Family Court, filing in the New York Supreme Court was unneeded, as we should obtain custody rapidly and be able to take that decision to France to ensure Nolene's swift return. We indeed won our Hague case for my daughter's return in December 2013 in an especially strong ruling, including damages and provisional enforcement. But on the deadline for her to be back, January 14, 2014, in the US, the mother evaded French police, hospitalised Nolene claiming my 8-year-old daughter was suicidal, and filed an appeal, again on the same disproven claims. Unbelievably, despite my career as a peace and human rights activist, the mother and her lawyer newly claimed I had become a terrorist to incite racism among the provincial judges. The mother and her lawyer invoked Article 13b of the Hague Convention. Article 13b stipulates the return of abducted children can be denied if the child is in grave physical or psychological danger. It was written to protect children fleeing immitigable harm such as natural disasters and war, or abuse in countries where there are no judicial or family mechanisms in place to protect children. Article 13b was not written for places like the United States and New York, where vast child protection structures are in place, nor for cases like ours with long, proven histories of false allegations. The Hague Convention was written specifically to prevent forum shopping of this kind. My long-proven innocence and our agreement preempting any French court involvement should have guaranteed my daughter's immediate return. But in a travesty of justice, the New York courts refused to release to the French court the forensic report that proved the mother had falsely accused me and that my daughter had never been abused. The court insisted that forensic reports are too sensitive to release to foreign courts, making it impossible for me to rebut the mother's hearsay beyond doubt. The French appeals court did not investigate, ignored our custody agreement, and the vast history of US decisions dismissing the mother's claims of abuse and upholding my parental rights. The French courts even ignored a letter the Queen's Court had sent them, in which the Queen's Court asserted continuing jurisdiction in New York, informed the French court that our case had been open here since before the Hague trials began in France, and invoked the Uniform Child Custody Jurisdiction Enforcement Act. Unbelievably, the French appeals court refused to return Nolene on claims of abuse that had repeatedly been disproven. Sadly, this is not the first story of its kind. We hear tales like this all the time. There are hordes of children who have been abducted to other Hague countries, and all that the kidnapping parent had to do was to evoke Article 13b. It's not unheard of that therapists have falsified claims of abuse to support the accusation. And that would be it. There would be no returning of the child to his or her home country. It's a slippery slope that ultimately leads to nowhere. A lot of times, it's the intervention of the authorities that is needed most, and when no one with the power is willing to cooperate, there are little options for the left behind parents. Naturally, the court will weigh up whether it is advisable to return the child to the left behind parent if there have been claims of the child being subjected to physical, emotional, or psychological danger. Of course, there are circumstances where these threats are certainly very much real and the child had been previously exposed to abuse or danger. We are absolutely not disputing that at all. We thoroughly support any decision that ensures a child's safety, where there are genuine risks involved, or if the child was previously harmed in any way. We absolutely do not condone any parent who is or has been abusive towards their child. No, this is only about those unscrupulous and ruthless parents who will stop at nothing to have things go their way. And this often tends to include concocting all these false accusations and claims against good and loving parents. One of the main issues with Article 13b is that it's somewhat vague, and it's basically down to the interpretation of the ruling court that is passing the judgment. Since its inception, it comes as no surprise that Article 13b is one of the most contested issues in the matters of international child abduction cases. A scholarly article published in the Chicago-Kent College of Law explained, "Courts in different jurisdictions have had difficulty interpreting Article 13b. On its face, the grave risk of harm exception appears to be in contradiction with the main objectives of the Convention. As one of the exceptions to the prompt return mechanism, Article 13b protects the best interest of the abducted child by giving priority to protection of the abducted child's safety and health over its repatriation to its place of habitual residence. On the other hand, the Hague Convention protects the best interest of the abducted child by promptly returning it to its place of habitual residence and thus deterring international child abduction. In addition, neither the text of the Hague Convention nor its drafting history defines grave risk of harm or intolerable situation. Although the courts in different jurisdictions have attempted to strike a delicate balance between prompt return mechanism and the grave risk of harm exception, some courts have interpreted Article 13b improperly because of its ambiguity and its facial contradiction with the Hague Convention's main objectives. International treaty interpretation is governed by principles as compiled by the Vienna Convention on the Law of Treaties. Pursuant to the Vienna Convention, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty and in light of its object and purpose. Treaty terms are viewed in their context in light of the treaty's object and purpose. Context should include subsequent practice that establishes the agreement of the parties. Based on these recognised principles of international treaty interpretation, this paper seeks to determine the meaning grave risk of harm exception by putting it in the context of the Hague Convention and by considering the purpose of the Convention. Additionally, this paper criticises the current interpretation taken by most contracting states in their application of Article 13b, as it fails to serve the Convention's purpose of protecting children's interests. Finally, this paper proposes a modified approach of interpretation that will better serve the Convention's purpose. Another grey area in Article 13 of the Hague Convention stipulates that the courts could refuse to order the return of a child if the child objects. It clearly says, "The judicial or administrative authority may also refuse to order the return of the child if it finds that the child objects to being returned and has attained an age and degree of maturity at which is appropriate to take account of its views." The general way that this is approached is that the court has to decide whether the child objects to being returned, and also if the child has reached an age of sufficient maturity to be able to make that decision. There is little doubt that it can become even more complicated when trying to determine if this is the child's own natural objection, or if there may have been any influences or brainwashing from the abducting parent. Supposedly, this is why they stipulate that the child needs to have reached a certain maturity at the time. But then, of course, it can be incredibly difficult to ascertain how much of the protest is the child's and how much of it is an influence. Again, we must stress that we are fully supportive of children being kept far away from any harm or abuse. And if a child has made genuine statements about not wanting to return to a parent because of fear or intimidation of such acts, then, of course, they should be absolutely not returned to such a horrendous situation. But no, what we're addressing here is the issue of those cruel and devious parents who may be using brainwashing tactics to try to turn their child against their good and loving left behind parent. Believe me, we've seen it happen enough times. Take for instance the case of an Australian mother's application where she suspected the boy had been manipulated against returning to her, as discussed by Healy O'Connor solicitors. The British father and Australian mother married in England, where their son, now 14, was born. They separated when he was 3. For the next 8 years, the boy and his mother lived in this country, with the boy keeping in touch with his father. The mother and the boy then went to Australia for a trip, intended to last for a year, with the consent of the father. He agreed to a further year's extension. During that time, the father maintained contact by visiting Australia, and on 2 occasions the mother brought the boy to England. On the second of those occasions, the father promised he would return the boy in time for his return flight in January 2013, but failed to do so. He claimed that the boy did not wish to return to Australia with his mother. The Kafkas officer considered that the boy was mature, saw his home as England, and had formed the considered and deliberate view that he did not wish to return. The mother considered that he was a vulnerable child and had been manipulated by the father. The mother returned alone to Australia and launched the present proceedings under the Hague Convention on the Civil Aspects of International Child Abduction 1980. 1. Under Article 12 of the Convention, the boy had been wrongfully retained in England. He was habitually resident in Australia and his mother was exercising rights of custody in respect of him. However, although the basis for his objections to returning may or may not have been right, his views were rational and amounted to an objection within the meaning of the exception in Art 13 of the Convention. In light of his age and maturity, they should be taken into account. 2. In considering the boy's welfare, the court would exercise its discretion not to return him to Australia, and any further questions about his welfare would be decided by the present court. One of the most famous child abduction cases is that of Sean Goldman, who was abducted from the US by his Brazilian mother and taken to her home country at the age of just 4. The trip was initially meant to be a 2-week holiday, but once there, his mother filed for divorce and did not want to allow the boy's father, David, to see him. After Sean's mother died in a childbirth, his stepfather then continued the custody battle along with his mother's family. A psychologist interviewed Sean when he was 9 years old, and the testimony was transcribed in the court. In his testimony, Sean stated time and time again of his insistence of wanting to remain in Brazil and was adamant about not wanting to go to US or to see his father. He did not feel any bond with his father and spoke of his father in a hostile manner. At this point, he'd spent almost 5 years in Brazil and would have only had fleeting memories of his father, David. It was obvious that Sean's statement was a result of the heavy influences of his Brazilian family, who Sean had lived with for that long. In an interview with Good Morning America, David said that Sean was trained to forget him. Eventually, Sean was returned to the US to his father, and he spoke to Today, where he admitted that it was hard at first because he didn't really know what it was going to be like in the US, and that he wasn't really given any prior information that was good, but the change was good, and that he and his father were happy. Now, there's just one remaining topic that we want to cover just very quickly. Another grey area in the Hague Convention is Article 20, which states, "The return of the child under the provision of Article 20 may be refused if this would not be permitted by the fundamental principles of the requested state relating to the protection of human rights and fundamental freedoms." Okay, so maybe that sounds like legal mumbo-jumbo to the untrained ear. So let me break it down a little better for you. In simple terms, under Article 20, a court is not legally obliged to return a child if there were questions about said country in relation to human rights or freedom. In all honesty, it's not that often that Article 20 is used in child abduction cases. But of course, that doesn't mean that it doesn't crop up from time to time. Carlton Fields discussed one such case, saying, "Decisions from other countries under Article 20 are rare. In one such case, Recognising the defence, a Spanish court denied a father's petition for return of a child to Israel from Spain. The child and mother were Spanish citizens. The court found that return would be contrary to principles of Spanish law concerning the protection of human rights and basic liberties. Following the parties' divorce and mother's taking the child to Spain, the father applied for and an Israeli court granted him sole custody upon a finding that the mother was immorate, a status under Jewish law meaning she was a rebellious wife. The Spanish court determined this finding would result in the absolute negation of the mother's parental rights and status in the Israeli community and declined to return the child. Rona Shuz stated in her book, The Hague Child Abduction Convention, a critical analysis, that Article 20 was included in the convention after much debate as a compromise between those delegates who wanted a wide public profile defence and those who are opposed to such a defence, and she indicated that it's very rarely pleaded and not often successful. She did go on to say that there are some indications that courts might be more willing to use Article 20 defence if countries with non-Western religions and cultural norms join the convention. In any event, Article 20 can be evoked where it has been established that the relevant human rights of either the child or the abductor, or in theory, someone else, would be violated by the return of the child. So who knows how Article 20 will next evolve, and since it is at present so vague and open to interpretation, we shudder to think how those underhanded parents and people in their authority may use that to their benefit. And that is where things can truly start taking a sinister turn, as ultimately the one who pays the most and loses the most is a vulnerable and innocent child. If anyone was affected by this episode today, or if you are or know someone who is a left behind parent, please feel free to contact our offices to find out more about how we can help you or offer advice or further support. Our team has a wealth of experience and expertise in this area and deal with cases like this on a daily basis. I encourage you to share this video with your friends and family. This is something that can affect parents and children everywhere, and we need to join in standing up against these injustices and to raise awareness. That's all we have time for today on our show. Thank you for joining us again for another episode of Kidnapped Hearts. Tell us what you think on our Facebook page at facebook.com/childabductioncourt.org or on our Twitter page at childabductionc. You can also drop us a line at our website, childabductioncourt.eu, or in the comments section below this video. Be sure to tune in next week for another hard-hitting episode with nothing but the facts.